Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group, and it's a place for thoughtful conversations on environmental and natural resources law and policy, ranging from the latest developments to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. And listeners, to quote from that great American song, "Oops, I Did It Again," I wanted to let you know that this upcoming episode is going to be the first part of a two-part series on government investigations, government inspections, and so forth. We've had this great problem over the last few episodes where we've had conversations that have run long, but we don't want to presume on your time. So we're breaking this into two chunks. The first episode is going to involve a discussion of best practices for preparing for government inspections at facilities, what you can do ahead of time to get ready for when the government knocks on your facility's front door. Our second episode, which will be coming out in a couple of weeks, is going to be focused more on what to do when the government is actually there. So I hope you enjoy the conversations that we have, and we look forward to hearing from you and hearing that this was helpful, and we'll talk to you soon. I'm joined today by Kevin Collins, a partner in our Austin office who has experience as an assistant United States attorney, and by Seth, Charme, a partner in our New York office who's previously had the role of acting U.S. attorney for the Eastern District of New York. Seth also hosts our Sidebar podcast, which is focused on government enforcement and investigations, particularly in the white-collar context. Go give that podcast a listen, subscribe to it, rate it. Just make sure you rate the Environmental Law Monitor slightly higher or say nicer things when you leave a review. I'm excited to be joined by Kevin and Seth today because I thought we'd talk about how facilities can respond to government enforcement and investigations, particularly on-site inspections, questions, document requests, and so forth. This is not at all connected to what you may have been reading about in the news of an inspection and a seizure of some documents at a certain hotel. Although that did get me thinking about coming back and circling back to this perennial topic of how companies can prepare for and respond to these initial enforcement actions from government agencies and from DOJ. So thank you guys for being here with us today.
It's a pleasure to see you again.
Yeah, happy to be here.
So I want to talk sort of generally about government enforcement and inspections, investigations, and we'll keep it at a pretty high level, but I want to think about what are sort of the best practices in preparing for the eventuality of those kinds of inspections, then what to do on the day of the inspection or the day of the site visit. So those are kind of our two topics to discuss today. And I'd love to hear from both of you, maybe starting with you, Kevin. For any company that has regulated facilities or sites, what are, in your view, some of those best practices that companies can start doing now to prepare for the day when their facility is visited for an inspection or subjected to a deeper investigation by DOJ or an administrative agency?
Well, first I'm going to answer your question, but then I'm going to shift and talk about something I want to talk about with Seth for a minute while I have him on the line. I think you need to have a plan and you need to understand what authority the agency is presenting to you to gather your information or, come onto your facility. I mean, that's the answer. But before we get there, I kind of have, and Daniel, you mentioned this in your intro about stuff that's going on in the country. There's this sort of primordial question that I have for Seth. I just want to get his thoughts because of his unique background. I perceive that the government currently is being more aggressive and using more tools in their toolbox. And we're seeing media reports of challenges to that aggressive posture. And that just has me concerned. And I just want to see if Seth has a similar view or what his thoughts are. And we can go back and forth on that for a minute. And we'll come back to, how to have a plan in a second.
Sure. So look, my thoughts on this are informed by about approximately 18 years in law enforcement in different capacities, initially as an operational person in the Marshal Service, where I conducted searches and sought search authorities, through legal process. And then sometimes just the existence of an arrest warrant allowed you to go into someone's home, which I think we would agree is probably the most intrusive type of search. And then I've, seen an evolution. There's an evolution certainly in the jurisprudence as it relates to technology and what can be gleaned about a person from, for example, the records on their phone, which today look very different, or the records about their phone, which today are very different from what they were, 20 or 30 years ago in the Supreme Court. has given continuing guidance to the government about the authorities required and the scope of searches that it conducts in connection with criminal investigations. And it's considered things like trespass doctrines. If you put a GPS wired into the battery on somebody's car, or, like I said, the phone records, if you have geolocation information about somebody for every second of every day, that's not simply who you called, which under some third-party records doctrines, going back a few decades, was a less intrusive search. So I think, to start out, Kevin, in response to your question, search jurisprudence has evolved reactively, right? Because the cases are always behind the government action. It takes a while for them to move through the court. Technology has certainly evolved. And at its core, to analyze the reasonableness of a search under the Fourth Amendment, you're talking about people's reasonable expectation of privacy, talking about the intrusiveness of the search, and you're trying to balance, the government's interest in investigating and in enforcing the law with the personal privacy interests of the individual. So I know none of this is news to you, but what I would say is the instrumentalities of searches have evolved rapidly. So, and there's been a slight disconnect, I think, between the law, the standards, and then how you apply certain search instrumentalities. We could spend a lot of time talking about, technology, and there's been a lot of discussion about that. But just in terms of the level of aggressiveness, I think it depends on where you point the spotlight, right? In terms of aggressive government action. And there are usually, pendulum swings, sometimes wide and sometimes narrow in terms of enforcement priorities, right? So every administration is tough on violent crime. But within violent crime, you're going to have bookends that you can adjust to see how aggressive you want to be. In white collar crime, the administration came in and they announced a very aggressive policy towards corporations and individuals in white collar crime space, and directed through command intent a lot of investigative efforts, pointed at corruption in all its forms. And they rolled, they put task forces together, and they signaled that they were going to be directing a lot more energy there. But at the end of the day, for a search warrant, to be obtained, you're still going to have some independent, you will have independent review from the bench. You'll have to make out facts establishing probable cause, right? That the evidence of a crime is going to be found in the premises to be searched. And so it's hard in real time to always identify, where there have been spikes in more aggressive, enforcement action. And frankly, the ones we tend to see are the more high profile cases involving public figures, where early on there's sort of counter messaging to the government. There may be more aggressive litigation, in an effort to suppress the fruits of the search. So not to give you too much of a lawyer's answer, but I would say the trend has been that the government has more tools, more incentive to conduct searches, and the case law has been always lagging behind the strategic moves by the enforcement agencies and the tactical moves. So sometimes you don't really know what's happening now until you see how it plays out, in litigation or a year or two down the road. Quite aggressive in some spaces. We've always been quite aggressive. Other areas, I think, are still evolving. And I'll be very curious to see, particularly in the white collar area, what gets litigated in the next, in the years ahead, when the department has said, essentially, go fast, take chances, go after corporations. The deputy attorney general literally said, we know there are going to be some acquittals because these are hard cases, but go get them. That statement alone suggests much more highly aggressive investigative action from the department.
Yeah, no, that was the kind of statement I was thinking about.
Well, I also think it's a little bit like each administration, whenever there's a new administration, the chess table is reset. And at the, and what's called the opening game or the beginning game, both players are trying to get their pawns into the places they want to get them into and develop a couple of pieces so that you are ready to move into the mid game and obviously get to a checkmate. And I think about the first couple of years of any administration, like those opening moves where you've got to issue new guidance. You've got to identify what areas you want to be your enforcement priorities. But I think after a couple of years, you start shifting towards the mid game where you've developed your pieces, you've got some of your policies in place, and now you're really ready to start taking some material off the board. And so I don't know if that's something that affects every administration especially when there's a change in the party, but it does seem like that's kind of an analogy for what is perceived to be an uptick in enforcement activity, but also seems sort of normal for us to be experiencing that kind of mid-game feeling.
To pick up on your chess analogy, one thing I see in terms of a mid-game move that I'm seeing in the government, more so in the criminal space than the environmental space, although those are converging, is there's a lot of warrantless acquisition of information going on right now. And I'll give you one example, and Seth hinted at this, but there are lots of commercial providers that will sell your geolocation information to the government if the government will ask them and pay for it. And there's a tremendous amount of information about your day that's locked into your phone. Even if you've turned your phone off, it will upload to Google or upload, if you've got Gmail on your phone, Google knows what you did today, and they're going to know what you did tomorrow. And if the government, or what you will do tomorrow, and if the government's interested in you, they'll go get that, and they won't need a warrant for that. And that's what I think Seth's getting at about, here are these tactical moves that are happening, and in a year, 2 years, 3 years, we'll figure out if, that's legal or not. But that's what's happening in real time.
Yeah, that's a great point, Kevin. And I mean, just to conceptualize that, right? The Fourth Amendment protects people from government action. I mean, that's what it's designed for. And the government essentially grew up learning how to navigate those Fourth Amendment requirements to conduct searches, particularly intrusive searches. But you're 100% right. The Fourth Amendment doesn't protect you from Google and TikTok and Instagram and every other website you visit where you blindly sort of agree to terms. And that information is now a commodity, a very valuable commodity. In fact, a lot of these products, whatever service they purport to provide is just a very thin, superficial veneer to the business that they're actually in, which is collecting and selling data. And that presents a really interesting question, right? Like because this notion of a reasonable expectation of privacy, and you can certainly voluntarily give away private information, but how important is it, to the analysis of where you expect that information, to go? And do the terms of services, how do those interplay with essentially the constitutional protection set up to safeguard you from overly aggressive action? I'm sure the government would say, well, look, you gave the information away, so you've lost your expectation of privacy in it. Why can't we just buy it and collect it? And I think probably what, a person very much invested in protecting privacy would say, well, we're kind of comfortable with the commercial use, but what we're a little worried about is the government's ability to collect, amass, retain, query huge amounts of information in perpetuity that may someday come back to prejudice us. And I think courts really are struggling with those concepts.
This is all super interesting because I think in the environmental context, those themes are all the same, but it may not be geolocation data of particular employees that's being sought. It may be other kinds of data, or it may involve citizen groups going and collecting citizen science, using infrared cameras to look at your facility to identify leaks and turning those over to agencies. It may involve citizens flying drones with cameras over your facilities or peering over your fence line. My point is, regardless of whatever industry you're in, there are individuals who are figuring out and groups figuring out how to collect information about what you're doing using new technologies, whether that's data collection or something like a drone. And they're going to be doing interesting things with it. But I do want to circle us back to that preparatory comment, given that we are in a period that we've sort of talked about. To distill our previous conversation to two simple points, I would say, one, there are new ways of collecting information and transmitting information to the government. And then governments are also ramping up in enforcement consistent with the priorities that they've laid out at the beginning of this administration. So with that as sort of a nice, I think, backdrop for what's going on right now. For any company that's, regulated particularly by the EPA, but by any government agency? What are those best practices that, given that backdrop, they can adopt and do that would prepare them for being inspected or investigated?
Yeah. So I think on the inspection front, that inspection question, when I hear you ask that question, I'm thinking to myself, if I'm a plant manager and OSHA shows up or EPA shows up or some other investigative body shows up, do I have to let them in the door or not? Right? Is that part of your question, or are you asking something different?
That's going to be part of my second question. I'm thinking more in terms of training. What kinds of training should companies provide to facility personnel, or what kinds of documents should that facility expect to keep on hand? Even if you have a corporate headquarters that has all of your environmental permitting information, what are the kinds of things that you want to keep on hand to show? And then any practices for preparing for unique or higher stress inspections, like unannounced inspections or sort of novel information gathering requests. So that's kind of what I'm thinking of. So maybe, I know, Kevin, you do a ton of tabletop sessions and dealing with incidents and incident response. Is there something like that in preparing for a facility inspection, for example? What can companies be doing right now, even if they're not going to be inspected for the next year, to get ready for that inspection?
Sure. I think you can create very simple plans with lots of white space, something that's easy to read when the inspector shows up. But you need to let your security staff or your gate people know what to do if someone shows up and presents credentials. They need to understand, they can take the credential or not take it, but they can look at the credential and sort of call to validate whether or not the person that's standing there is in fact from the agency that they represent themselves to be from. There's nothing wrong with that. Agents understand that that's something that will be done. And then if you want to get more complicated, some of these statutory authorities that allow for inspection, they allow for government agents to come into your facility under the appropriate authority. They may not authorize these extra people that they're bringing along to come in. And so you can distinguish between, among the three of us, two of us may have the right to be in and one of us may not. And you could say, look, we're happy to let, the first two of you in, but this other person doesn't have authority to come in. That's a bold thing to do, but I think you need to be empowered to at least understand that. So here's some things you can't do. You can't photocopy their credentials. You can't force them to sign a waiver of liability or, some document that gives away some right of the government or of their right. You can't subject the agents to heightened permit requirements that you wouldn't subject other people who are entering your facility on. In the administrative context, those are some things you can't do. I don't know, Seth, if I left anything off.
No, that sounds right, Kevin. And I think just in principle, you have to know your rights to assert your rights. You have to know the rules to be able to navigate the rules. And to do it with confidence, it helps to practice and prepare. Most of us, certainly, as lawyers, we know what our rights are when we're pulled over by a state trooper. It's one thing to know them. It's another thing to assert them, when you're confronted with questions, even if just to personalize it for people, And I think in the corporate context, it's the same. Like you've got to know what you're not allowed to do. You also have to know what they're not allowed to do. And you've got to be comfortable, confidently asserting your rights without aggravating the situation. And I think that only comes through practice and rehearsal and training.
And that's one thing we do offer to Bracewell's clients is we will offer inspection tabletops, search warrant tabletops. We could do those by surprise and not by surprise, depending on what the client wants to do. But it's good to exercise that in the same way that we do tabletops for responding to an incident. I mean, a search warrant execution is a form of incident. An inspection presentation could be considered a form of incident. And so going through those motions and seeing how your people actually, whether they've read your policy and know how to execute your policy and know their rights, like Seth was saying, it's something we can definitely test. It's pretty easy to do.
But it seems like there is a need to be proactive about developing that muscle, right? Developing that muscle so that I think especially when you don't have advance notice of an inspection, and you might not always get that advance notice from an agency, particularly if they believe that something more severe is going on at a facility, they may show up unannounced. So I think that working through that, it's just kind of practice for the game, right? You've got to be able to practice those important moments before you actually get to one where points are actually going up on the scoreboard.
Yeah, these things always go more smoothly when you act professionally and calmly. That doesn't mean, you give away the farm and volunteer things you don't have to. But having that confidence to act calm and professional in what is undoubtedly going to be a stressful situation is really important for the company. Because, look, people can appear guilty just when they're nervous, and they can arouse suspicion, just through kind of erratic behavior. And you can lose confidence quickly if the inspectors or the agents, get the impression that you're either willfully trying to disobey the rules or you're trying to mislead or misdirect them. So you want to have that confidence, professionalism, know your rights, keep the temperature down, and everything goes more smoothly for everyone involved.
All right, we'll stop our episode there. Stay tuned for our continuation of this conversation. Look for that in a couple of weeks, and we'll talk to you soon. That's it for us today at the Environmental Law Monitor. Big thanks to our guests, as well as Dorn, Julia, and Emily, and the rest of our production team who helped to make our podcast possible. And of course, you, our listeners. We'll talk to you soon.